Senior Advocate of Nigeria, Mohammed Ndarani, has said the recent judgment by the Federal High Court in Abuja halting further allocation releases to Rivers State highlights that the state has been living on borrowed time financially. Ndarani made the statement on Thursday in Abuja following the judgment received by Justice Joyce Abdul Malik in response to a suit filed by the Rivers House of Assembly and Martins Amehule. The suit marked FHC/ABJ/CS/984/2024 sought to restrain the Central Bank of Nigeria from disbursing funds to the state, a request granted by the court. The Sun noted that the judgment affirming that a state cannot function without a properly constituted House of Assembly aligns with the constitutional provisions and reinforces the rule of law. Governor Siminalayi Fubara had earlier presented an 800 billion naira appropriation bill for 2024 to only 4 out of 31 members of the State House of Assembly, a move the Court of Appeal described as a gross constitutional violation. He said, for those who understand constitutional democracy, Justice Abdul Malik's ruling should not be surprising. Rivers State, led by Governor Fubara, has been living on borrowed time regarding state allocations, he added. He emphasized that Nigeria's constitutional democracy mandates adherence to the rule of law with a properly constituted legislature, essential for checks and balances. He further argued, a governor has no legal right to spend public funds without legislative appropriation. Such an act would be unconstitutional under Section 120 and could qualify as gross misconduct, possibly leading to an impeachment under Section 188 of the Constitution. Ndarani also noted that unauthorized spending could expose a governor to allegations of misappropriation as per Section 108 of the Criminal Code, while the public procurement law limits unappropriated expenditures to emergency cases under Section 121 of the 1999 Constitution. He stressed that the House of Assembly's oversight rule ensures accountability, curbs misuse of funds, and directs public expenditure towards the state's benefits. Without it, he argued, the executive branch risks undermining democratic principles, the rule of law, and the constitutional separation of powers. The senior lawyer concluded by citing Section 120, subsection 2 to 4 of the Constitution, which requires legislative authorization for withdrawals from the state funds, asserting that any breach represents a critical failure in governance. Honorable Don, what do you make of the story?
Anyways, I fully agree in totality with my learned senior friend, whom have laid proper foundation as to what the governor has made of the public funds as far as Rivers State is concerned. As of today, it is important that we let Rivers people understand that the governor swore on the 29th day of May, 2022, that he was going to uphold the tenets and spirit of this constitution. And by going by that, it will mean that upholding the tenets and spirit of this constitution will mean that to follow this constitution in all its letters and intent, ipso facto, there is nowhere the law gives the governor opportunity to discretionalize issues that have to do with public interest. And so therefore, it is not an option for the governor to follow what the provisions of the law have stated, as this constitution have so made it clear. So therefore, the governor does not have an option, but the law mandates him. It's not a discretionary action. The law mandates him that at this point, before the next fiscal year, the law mandates the governor to present a budget before a well and known or recognized legal, members of the House of Assembly. So it is a non-law. It is not a discretionary issue. When the governor started presenting budgets to 4 out of 31 members, 32 members of the House, it was an infraction of the Constitution. Section 91 clearly states, in fact, going by the same law the governor swore to uphold, Section 91 says that the House of Assembly shall not consist less than 24 persons and no more than 40 persons. And so where you present a budget to 4 persons out of 32 constituencies, what it means that you have shot out about 27 constituencies, and knowing that what the House of Assembly, the members of each of those constituencies are representing the interests of their different constituencies. So when you present budget to 4 out of 32 members, it means you have technically shot out 27 constituencies from a budget that they ought to make contributions to. So that alone is a moral infraction. Now, when it comes to the Constitution, the Constitution says a House of Assembly shall consist of nothing less than. If you look at the word of the law is very mandatory. It's not discretionary. The House of Assembly shall consist of nothing less than 24 and nothing more than 40. I hope you understand. So what it means is that when the governor presented a budget to 4 out of this number, it means that there was a wrong presentation of budget. And in other words, there was no presentation at all. And the Court of Appeal have even made it more clear that the actions of the governor amounted to executive rascality. And I agree with them in total. In fact, what is my problem today is how the governor, because of his actions and the actions of those persons who are grandstanding with his ideology, have ridiculed the judiciary. In fact, in my entire life of practice, this is the first time I am seeing the judiciary being ridiculed, even by a mechanic, somebody that doesn't understand English language. Most of you do not understand English language. You see, as of today, even a mechanic will sit down and want to interpret a court judgment.
But then, Honorable Don, when you say that, on my show, I have also had the privilege of having lawyers, seasoned lawyers as well on my show. And they also, sometimes I have up to 2-3 lawyers at the same time on my show. And when I have 2 or 3 lawyers, I have different interpretation to one judgment. And sometimes different interpretation to one section of the Constitution.
The thing is that when the law is clear, that's why people go to court. Okay? People will go to court because you want the court to give a clear interpretation.
Yes, go ahead.
You give a clear interpretation as to what the law says. Now, where the law uses the word shall, it's mandatory. The law says, Section 120 of this Constitution, subsection 4, clearly says that no money shall be withdrawn from the Consolidated Revenue Fund of the state, okay, or any other public fund of the state, except in the manner prescribed by the House of Assembly. For crying out loud. If you mark Section 91 and then Section 120, subsection 4, you would agree with me that by those provisions, the presentation of the budget to persons less than 2/3, not even 1/3 member of the entire constituencies is a gross constitutional infraction. It's a gross constitutional infraction. So it doesn't, there is no gainsaying that it is not important how any person feels. It can be emotional. But what I'm discussing is law.
Now, talking about the last comment you just made, it's not important how anybody feels. There appear to be 2 schools of thought in River State crisis. Now, the law on its own is clear what it is. However, on the other side, we have the position of the governor. We have the position of the law and the position of the governor and the supporters of the governor. Now, the position of the governor is that he derecognized the River State House of Assembly, and he has chosen to work with the 3-member house, 4-member, in fact, still 4-member house, because the River State House of Assembly has come out to say that they did not receive any resignation letter from Edison Ehe, the now chief of staff. So he still remains a member of the house. Is that correct?
That's not, in fact, see, let me tell you, but we cannot deny that he resigned.
To what house? A house known to the law?
He said he has resigned. But that's by the way. Now, I'm more concerned with what the law is saying. The law says a constituted house of assembly known to law. Section 109 subsection G, 1 sub G, is not self-executory. I challenge anybody, it is not self-executory. Because as at today, among all the school of thoughts, legal school of thoughts, Nigeria is practicing the pure law school theory. And what is the pure law school theory? The pure law school theory is of the view that law is what the courts will make pronouncement on. Why do you go to court to challenge your right? If it was self-executory, why would you not execute it yourself? Your right is taken from you, you go to court to challenge it. That's to tell you that this constitution is a guide, and then the court will now direct that follow this guide. So what Nigerian jurisprudence is all about is Nigerian jurisprudence is far tailored towards the pure law school theory. And that's what the law is. It's nothing more pretentious than what the court says is what the law is. That's what the pure law school theory says. So the ideology of people saying it's self-executory, I disagree with them in total. This constitution is not self-executory. The reason is because for this constitution to have this constitution will be added flesh by the court. It is a bone. It is a skeleton as we speak to you. It is a court that adds flesh to make it a full-fledged law. It is a body of law that the court must act on for it to have effect. So in Nigeria, it is, I should make it clear that what we practice is the pure law school theory that says it is only what the court says and nothing more pretentious. It's what the law is. So when people begin to say it is self-executory, my dear, I disagree, and this is not what the intention of this constitution is not what some people perceive it to be.
But however, that conflict in school of thoughts in this instance has brought River State to where it is right now. And now River State is now faced with a seizure of its allocations. Yeah. Let's delve into the judgment of Justice Joyce Abdul Malik, because I mean this judgment, some people consider it controversial. It's raising a lot of reactions from different quarters. Atiku, for example, has come out, the former vice president and the 2023 presidential candidate, under PDP, has come out to condemn the judgment of Justice Joyce Abdul Malik, ordering the CBN to seize River State allocations. And the NLC also has come out to make their own statement, and they are threatening to down tools if the salaries of workers are affected. Now, one of the arguments that the NLC chairman presented was that this judgment does not have a human face. An analyst on my show said that the money that is being seized is River State money, and that the state has compulsory financial obligations, some deductions that are made at source. So now the state will be running into serious problems with investors and financial obligations that it must meet up with. And we also have to consider the effect of this on the workers, the civil servants. What do you make of this and the reactions and concerns from different quarters?
Well, as well as I will really sympathize with the outcome or the adverse effect the judgment we have on Nigeria, the River State workers, I would not expect the Nigerian Labour Congress to begin to grandstand, making it look as if they are in sympathy with the Simplify movement. Obviously, it is not an action that they necessitated. This was the effect of disobeying the provisions of the law by the governor. And the effect of disobedience is this kind of thing, it's punishment. The law says when you disobey, you'll be punished. The affidavit that the justice, the plaintiffs, averred before the court was going to show that there was gross violation of section 120, 121 of the Constitution. And they were able to show the court that between January and now, the governor had not presented a budget to the well-considered House of Assembly. No, let us look at it. Let us see what is happening in Rivers State. As I speak to you, I am bothered because never before have we plunged ourselves into this crisis because of bad emotions, ethnic sentiments, bad advices to the governor. People feel because he's from one part of the ethnic group, they feel that this is their turn. In law, they are nothing like turn. What the law recognizes is procedure. Follow the law. And I would have expected the governor, I've said this clearly before now, on this show, that I would advise that the governor forget about this side attraction, not a simplified movement and whatever they are doing, and follow the provisions of the law. If the governor was right in all he was doing, this law will protect him. This law is a two-edged sword. The law was made for every man, and no man for the law. So the governor had breached these provisions of the law. And so the punishment for breaching these provisions of the law is what the court had made an order. And of course, it's so worrisome. It's so worrisome. They have told you between January and now, you've not presented budget, and there are spendings from the consolidated revenue funds. Money coming from the federal government into River State allocation account, and then there are consistent withdrawals. Not to talk about the reckless lifestyle the members of the Simplified movement are living in River State, showing that there are gross disobedience to the provisions of the law. You see, when you don't follow the law, the outcome is punishment. That's what the law says. So the judgment of Justice Joy Abdul-Malik was not made out of emotion or sentiment. The judge was simply following what the law says. And where you fail to do what the law have said, then these are the deterrent measures that the court will put. Because we are a constitutional democracy. It's not a parliamentary democracy. It is a constitution that directs our modus operandi on our actions, everyday actions in this state. So what the governor, any person that becomes a governor, what he should become more conscious of is what is the provisions of the law saying. Your attorney general, your legal officer should be able to sit the governor down and educate him. Governor Fubara is not a lawyer, but I expected him to sit down with good heads, in the legal profession, for them to educate him properly, without sentiment, on the do's and don'ts. I am sure what the governor is acting on is emotion. And once you begin to act on emotions too much, you are bound to make mistakes. And even as a judge, by the time you become too emotional, you are bound to make mistakes. That's why people will recuse themselves. You remember, the judgment we are talking about, this matter was first before Judge Okorowo. And when there was consistent noise making, Judge Okorowo is like playing to the gallery, and this matter was reassigned
to Justice Joy Abdulmalik,
who had no idea, or let us put it differently, who had nothing to do with Rivers State. Not from Rivers State.
But then she was also asked to recuse herself.
No, it's because the chief judge of the Federal High Court had looked at it. We give it to this one, you say recuse yourself. We give it to this one, you recuse. Who can we give it to? And you will not ask us to recuse. Because it now amounted to like any matter that they file in Federal High Court, to the simplified movement, they believe that those courts are former Governor Wike's court. And it's not correct. And I want to warn the general public. They should desist from the idea of insulting judges for whatever it may cost. This is not political. I'm an apostle in the temple of justice. And this is my gospel. No matter what the judgment is, it is my advice that the judgment be obeyed, be enforced until it is set aside. Where people who are not lawyers, non-lawyers, people who are mad with very grievous ambition and emotions, begin to say that they are not going to obey court orders, or where they choose the court orders to obey, then you are plunging the democracy into very serious state of lawlessness. And of course, you know what that is. And any disobedience against the law is an infraction. And the state must go against. And that's why I like what the president has said. You know, initially, the local government councils were sealed up because of a court order. And then later on, when what appeared to be like an election, you know, was conducted, which I don't know where they derive their power from. In order for us to, for the president to appear to be neutral, he said, Inspector General of Police, at this point, unseal the local government council. Let it not be like, okay, we are, it look as if we are standing on one side. Unseal the local government council. But that I would await the outcome of the matters that are in court. That once the judgments are given, then the duty of the president and the federal government as chief executive officer is to make sure that those judgments are enforced. And I want to also advise that whenever these judgments come, it is our duty to obey the judgment. I have always advised my client and those that care to listen that whether you say a judgment comes from this court or not, please, it is your duty to obey the judgment until it is set aside. So I want to say that on the issue of the cessation of the state revenue, the allocation coming to the state, it is not the making of the state workers, but it was because of the gross disobedience of the governor.
So in this instance, you're saying that the state workers are collateral damage in this particular
obviously the impact of this judgment, no doubt, okay, would touch, you know, appear to touch on them. But however, I know Rivers State is a very buoyant state, and if the governor wants to, if he wants to be sincere to himself, without bringing in state workers, NLC coming in and all that to grandstand, the governor should be able to pay the workers from what they generate from Rivers State.
All right.